Okay, good morning, everybody. I'm Bob Bednars, and this is Bob's Coffee Chat. And today we have a very special presentation. We have Kelly Balamuth, who's been a California attorney since 1994. Kelly is a fourth generation San Francisco Bay Area native. She has been long committed to serving the people of our great state of California. Kelly lives in Moraga on a small farm with her husband and her crazy blended family. She graduated from UC Davis Law School and is here today to teach us about estate planning and how it can make your life better. So, Kelly, how can you make my crazy life better?
Well, let me tell you, I want to start off by thanking you all for being here and really honoring your attendance here today. I sincerely appreciate it. My name is Kelly Balamuth, and I'm the owner of Balamuth Law. And today we're going to be talking about estate and legacy planning and how to keep your family out of court and out of conflict. I believe that knowledge is power, and it's my hope that the information you're going to learn today will really empower you, will be educational, and will give you some peace of mind. I have a lot of valuable content and a valuable offer, so I'm going to just dive right in. The best way to learn is to turn off your phone and close out of all your windows you have on your computer. You really deserve this time for yourself, and you're going to learn the most if you really kind of shut off all those distractions. And as a bonus for sticking around until the end of my presentation, I'm going to be giving you a golden ticket worth $1,000 of estate planning services. I'll tell you a little bit more about that in a half an hour. So just to kind of get started and to kind of get to know you a little bit and where you're coming from, you could put this information in the chat box if you like. My first question for you is, do you currently have an estate plan? I'm going to pull up the chat box so I can see folks. And that could be that you have a will or a trust or some legal document in place to protect you and your family or your business. I see a few yeses. I see one started. There's a no. So if you've answered no, don't feel bad. You're not alone. 69% of Americans don't have any type of plan in place. And a lot of the reasons that I've heard from my clients about why they kind of put off this kind of legal planning is that they feel like they're too busy, that they're too young, or that they're afraid it's too expensive. So if those are some of the things that you've thought about, you're in good company. If you said that you do have an estate plan in place or some kind of legal documents, what do you hope to learn today? And it may be that you want a better understanding of what you have in place. Maybe you created something online and you want to know if it's good enough, or maybe it's outdated, either because there have been changes in the law since you put it in place, or because there have been changes in your family or your assets, and you want to make sure it's up to date. If those are any of the reasons that you're here today, then you're in the right place too. The biggest fear that I often hear that prevents people from doing this planning is this feeling that planning for it will hasten its occurrence, make it happen quicker or sooner. And the good news is I've worked on many cases with many clients, and I've never seen any correlation between somebody putting an estate plan in place and then suddenly having an unfortunate accident. So that's good news there. And you're in the right place for this webinar today if you have someone or something you care about and you want to protect. And you're also in the right place if you did a fill in the blank will or an online document and you're not sure if it'll work, because we're also going to address that. And you're in the right place if you're nervous about how much it'll cost to put together an estate plan, because we'll address that as well. The reality is that estate planning is not about you. It's not about me. It's about the people you love the most in your life. And your loved ones will know if you lived up to the promise of I took care of it when the time comes. So what you will learn today is how your loved ones can cope with the unexpected from two different perspectives. The first perspective is the before perspective, and that is no estate plan in place or a document here or there. And the after perspective is going to be a personalized, tailored estate plan, really a situation where the worst possible scenario of you passing away kind of turns into the best possible outcome for your loved ones. But before I jump into talking about that, I want to tell you a little bit about who I am and why I'm so passionate about estate planning. I've been an attorney since 1994. I went to law school at UC Davis, and when I graduated, I went into practice with my father. We were a family law firm of trial attorneys. For 25 years, I practiced personal injury law. One of the things I loved about being an attorney, is helping my community, helping people who have had a tragedy befall them get help. But doing personal injury law, the pattern I saw over and over was that tragedy would strike unexpectedly and people would have access to legal tools we're talking about here. And as a result, their loved ones were in court and conflict for many years. I became passionate about helping families gain peace of mind before something bad happens. By the time you're in a situation where you have to go to court, you're relying on strangers, a judge, or a jury to decide for you. And that's often a life or death situation. It's like gambling and it can make you crazy. So much of estate planning is the opposite of litigation. We don't go to court. We don't have to worry about strangers making important decisions for you. It's simply all about what you want and avoiding problems in the future. And we don't have to go to court to do that. In fact, most of what I do is put plans in place in order to keep people out of court. And as we'll learn by the end of today, estate planning lends itself to a flat fee model, which I believe really helps with attorney-client communication and encourages relationships long-term with our clients. I want people to feel comfortable speaking with me and to ask questions. My goal is to make access to legal services accessible to everyone. So my why, the reason I do these seminars is because I have watched many clients who were injured or family members of someone who was killed unexpectedly have to navigate being stuck in probate court, either because they didn't have an estate plan or because the plan they had failed. Being stuck in probate court can cause a lot of conflict and even tear families apart. Seeing that made me passionate about making sure people don't have to go through that. That's how my firm's designed, and that's why I do these events, because I believe knowledge is power. Here you can see my family. These are my why for doing this kind of law, and I understand the desire to protect them, and I want to help others do the same. I've received a few accolades in my career I want to briefly share with you. I've been recognized as a super lawyer many years running, and a few times named one of the top 50 women lawyers in Northern California. And AVO, which is a website that rates lawyers, has given me a 10 out of 10 rating. So that's a little bit about me. Now I have a question for you. Who is it that needs your protection? My answer would be my kids and my grandchild and our puppies. For you, who are the loved ones who would need your protection if you suddenly couldn't be there for them? So this might be your children, your spouse, nieces, nephews, your cousins, maybe your business, and maybe your business partners as well, whoever they are. If something were to happen to you, who would need your protection? We'll come back to that in a little bit. I do want to invite you to ask questions you may have. There will be a question answer period at the end where I'll try to answer any questions you've asked. So you can either type them in the chat box or jot them down for yourself and ask them outright at the end, just like Bob said. So today we're going to be learning about estate planning from a family, a fictional family called the Bliss family. The Bliss family is Mark and Molly and their 3 children, Alexander, Benjamin, and Caroline. They're just your everyday California family. They have savings accounts, they have retirement accounts, they have life insurance accounts. Mark and Molly got married and had Benjamin and Caroline. Alexander is Molly's son from a prior marriage. And the Bliss family also has 2 pets, Rio the dog and Whiskers the cat. As I mentioned, Molly was previously married to Xavier. Xavier was her college sweetheart and he was a big time partier. And he never really outgrew that. So they split and Molly got full custody of their son, Alexander, who you can see here in this picture. And as part of the divorce, Xavier updated his life insurance policy to have a $1 million payout and named his son Alexander as the beneficiary. And as I mentioned, this is an everyday California family, but they have some bad days ahead. And I hope you can bear with me as we put this family through an absolute train wreck. This is a picture of the train here. we're doing this so that you can really learn some important estate planning topics. I think you can probably tell from how I'm talking and how I educate that I don't take myself too seriously. I do take seriously you understanding these topics in a way that's very accessible and also a little bit entertaining. So I hope you can give me permission to put this family through some really horrible days as we learn together. So sad day number one for Xavier is that he turns 40. And it's not as sad that he turns 40. What's sad is that he decides to go skydiving, and in his excitement, he doesn't put on his parachute. And so, adios, Xavier. But remember, Xavier had that life insurance policy. In fact, that life insurance policy is the one responsible thing he did. After the divorce, he got $1 million life insurance policy. He named Alexander as the beneficiary, and he thinks that that was a great idea. But we're going to learn together that that was not, in fact, a great idea. Because Alexander is now a teenage millionaire, and Alexander is pretty stoked. He's imagining and dreaming about the sports car he's going to buy. He's 15 years old, and his mom, Molly, is not happy. She wonders if it's possible for a 15-year-old boy to inherit that much money. He really hasn't learned financial lessons. How is she going to make sure that the money is going to be used properly and responsibly? She calls my office to find out the answers to these questions, and I deliver the bad news to her, which is that we are going to probate court. So if you haven't had any experience with probate court, think of it as a court system. It gets involved anytime a minor, so anyone under the age of 18, inherits money. Minors can't inherit money directly, even with the life insurance policy. So if the life insurance policy is supposed to pay to a minor, it's going to probate court. Probate court's also involved if you pass away with a will or with no legal documents in place, but we'll talk more about that in a minute. So I deliver to Molly the bad news that we're going to probate court. As part of going to court, she has to submit to background checks. She has to submit information about her financials, which she finds invasive, but she really has no choice. And when we get to probate court, who else shows up but Zachary, Xavier's brother? Zachary shows up and wants to manage the money for his nephew. After all, his brother divorced Molly, and he thinks he would be the right person to manage the money. So we're in front of the judge, and the judge is going to decide who's going to manage this money for Alexander. Is it going to be Uncle Zach or his mother, Molly? So, question for you, you can put it in the chat box if you want. Who will the judge choose to manage the money for Alexander because he's a minor? Molly, his mother, or Zach, his brother, his father's brother? The answer is that we don't know. So I have to let Molly know that there's not a default. Just because you are the full custodian or have full guardianship of a child, it doesn't mean that the judge will automatically pick you. There's no default. So it is fully up to a stranger, the judge, to make the decision who would be the best to manage the money in this situation. So let's do something better for the Bliss family. All right. The first idea we have is Xavier updates his life insurance and names his brother, Zachary, who is an adult, as the beneficiary instead. The thought process he's going through is, okay, I've learned my lesson. Don't leave your life insurance to a minor because it ends up in court. So I'll just leave it to my brother and he can manage it for my son. That's actually a bad idea because Zachary is not required to use the money for Alexander because now it's Zachary's money. And because it's Zachary's money, it's exposed to his lawsuits, creditors, and any potential ex-spouse. So if he gets married, it could be considered marital property. There might not be any money left at the end of the day for Alexander when he turns 18. All right, idea number 2 is Xavier signs a will that says, I leave everything to Alexander. If he's under 21, I put Zachary in charge. That sounds like a good idea. It's really not a good idea. And what Xavier doesn't know is that your will does not control all your assets. Joint ownership and beneficiary designations override your will. So what does that mean? Okay, this is the most text that I have for an entire presentation. So Bear with me, but it's easier to think of this as three separate buckets. So the first bucket is that if you have any jointly owned assets, they go to your surviving joint owner regardless of your will. So what is a jointly owned asset? For example, if you own the title to your home and you own it jointly with your spouse, that asset will transfer to your spouse at your death regardless of what your will says. So even if you wrote your will saying something different, it doesn't matter. It will transfer directly regardless of your will. Next, any assets with beneficiary designations go to the beneficiary regardless of your will. So because the life insurance still goes to Alexander, even though he has written this clause in his will, it would still flow to Alexander and you would be back in probate. So beneficiary designations are things you would do for life insurance, for retirement accounts, things like that. Anything left in your probate estate that passes pursuant to your will, if you have one, or state law if you do not, those assets are not immediately available to your loved ones and must go to probate to get access to them. So that means that if you have life insurance designations for a minor, your child will not get immediate access. It has to go through probate. So this is the biggest myth, that if you have a will, you don't have to go to probate court. That's not true. A will does have to go through probate. So idea number 3 for the Bliss family is to create a living trust. Xavier establishes a trust that says, I leave everything to Alexander. If he's under 21, I put Zachary in charge. Do you notice that this is the same wording that we were talking about with the will, except we're now doing it for a living trust? So what is a trust? We're talking about a living trust at this point, and a living trust is a contract. It's an agreement, and in this situation, it's a substitute for a will. It does everything that a will does, except it does not go through probate. So we completely avoid probate, which means that it saves your family time, it saves them money, it saves them potential conflict. I'll go through that in a little bit more here in a moment. So let's think about those 3 buckets again in the terms of the trust. Any property titled to you, you put in the name of the trust. Any assets you jointly own, you put in the name of the trust. And any beneficiary designations are also updated to pour into the trust. If you do this, then all trust assets are immediately available for your loved ones upon your death. No court is required. And typically the court process, the probate process, takes between 9 months and 2 years. With COVID, it's up toward 2 years. So having trust assets available immediately is a huge advantage of a trust. So I like to describe a trust to my clients like a red wagon. There's no probate court for the toys or the assets that you put into the red wagon or that you put into the name of the trust. However, if you don't put your assets into the trust, and the legal word is funding, but it is essentially renaming or retitling, anything you don't put into the trust, it's like when you were a kid and you didn't have your toys in your wagon. It really invites conflict because those assets have to go through probate. So the takeaway here is that if you're watching this and you do have a trust in place, this is the biggest mistake people make. They don't update their assets to the trust, and therefore those assets have to go through probate. So lesson number 1, a review of all your assets must be part of your planning conversation. A document alone is not enough to protect you. Now, this is the biggest lesson, and it was the longest lesson. We really want to break it down, the difference between a will and a trust, but the next few lessons are a little bit quicker, I promise. All right, lesson number 2 is sad day number 2. The Bliss family's off to a ski weekend. They head up to Tahoe with their dear friend, Dina. The kids are all put in ski school and everyone is having a great day. But then a fog descends on the mountain. Molly and Mark collide in the fog and are knocked unconscious. But where are the kids? Their good friend Dina is in Tahoe with them. She loves the Bliss kids as if they were her own. She gets on the phone when this accident happened with Molly's sister, Mindy. Mindy's out of state, so she gets on the next plane to come to California. We're not sure how long it's going to take for Mindy to get there. So the situation is Mark and Molly are unconscious and the kids are in ski school. The big question is, who can take the kids in this situation? So as I mentioned, Mark and Molly Bliss and the Bliss kids would feel very comfortable with Dina caring for the kids during this emergency. If Mark and Molly could talk, they would say to emergency responders, please, please, please give our kids to Dina, but they can't. And unfortunately, in an emergency situation, only a blood relative can be a temporary legal guardian. Because the Bliss family doesn't have any legal documents in place, Dina is not able to take the kids. This creates a very scary situation for these kids who would have to be in police protective care until a conscious blood relative arrives. So let's do something better for the Bliss family. The first thing we do is put in place a temporary guardianship for Dina. This is something that I put in place for my clients so that the children are always with exactly who you want, no matter what. When I say the word guardianship, you might be thinking of who raises your kids if you can't. That's what we call long-term guardianship, but that's not what we're talking about here. This short-term guardianship paperwork is also given to Dina electronically. She keeps a copy on her phone so that she's able to show the emergency responders and is able to take the kids home with her that night. It's really important to note that these documents, electronic documents, will work in an emergency. For the documents to work, you really need to share them with the right people. So that happened here, and Dina pulled it up on her phone, and problem of what happens to the kids during this horrible emergency is solved. You can also put together these emergency options and plannings for any pets you have. I know a lot of people have pets, and I know that we have pets that we love that are part of our family. So Dina is also given the same documentation as she has for the kids for the pets, so she can pick them up from pet daycare. So lesson number 2 is guardianship is equally about what happens in an emergency as it is about who raises your children if you can't. And lesson sad day number 3, Molly's injuries linger and Molly is in the ICU. Mark, her husband, is making her medical decisions for now. Meanwhile, Molly's sister, Mindy, lands in Oakland International Airport. Mindy calls the doctor when she lands and tries to get some information, but the doctor can't tell her anything because of, can't get it to click, because of HIPAA, which is that big red stop sign, a federal law that keeps your medical records private. The doctors can't talk to her because she doesn't have a HIPAA release. So a few hours later, Mindy shows up at the hospital. Mark has been making medical decisions for Molly before Mindy arrives, but now that Mindy is here, they legally get to make the decisions together. And you might be thinking to yourself, but why? Mark is married to Molly. He should have the exclusive right to make Molly's decisions. But the big surprise is that he doesn't. The law says any interested person can make medical decisions for anyone who is incapacitated when there's no estate plan. So now Mark and Mindy are making decisions by committee. And if they reach an impasse, meaning that Mark and Mindy don't agree on what should happen to Molly as far as her medical care, then it would go back to probate court. Meanwhile, back at the bank, Mark can't access the money he needs to pay Molly's bills. And that's because when they got married, Molly did not update her bank accounts to add Mark. Her medical bills are increasing. Molly has money in a separate bank account for a rainy day like this, but when Mark walks into the bank, he can't get access to it because she has not added him to her accounts. Being married isn't enough for Mark to have access. So he's back at probate court to ask for access to those bank accounts to pay his wife's bills. So we're back in probate court, and who's there? Well, Mark is there as the husband, asking for access to the bank accounts and asking to be able to make healthcare decisions for his wife. Mindy also shows up in court. Mindy, Molly's sister, is asking for access to the bank accounts because, after all, her sister's money is money inherited from their parents. Mindy doesn't know Molly's new husband, Mark, very well. She thinks she should be the one to make Molly's healthcare decisions and manage the money. So who will the judge pick? Again, we really don't know. There's no default. It will be up to the judge, a stranger, to make the decisions about who should manage Molly's financial decisions and her affairs while she's incapacitated in the hospital. So let's do something better for the Bliss family. Prior to getting injured, Molly comes into our office. She makes her decisions, not the probate judge, about who is going to make her medical decisions. She decides her husband, Mark, is going to make those decisions. So she signs over a medical power of attorney to him and signs an advanced healthcare directive. She gets her sister, Mindy, a HIPAA release, which allows Mindy to get information, but not to make those decisions. Then when Mindy's plane lands and she calls the doctor, Molly's HIPAA release allows her to get information about her sister. And Molly herself, not the probate judge, decides who will handle her finances. She signs a durable power of attorney naming her husband for any situation if she's incapacitated or passes away. This allows Mark to walk into the bank with that document and pay the bills and get access to that money. So lesson number 3 is the only other person other than you who can make your decisions on your behalf as a probate judge if you haven't made the decisions in advance. So don't let that happen. All right. I want to share with you a little bit about how my process works and how you can get started with estate planning or with having your estate plan reviewed. The first thing I want to describe real quick is how my firm is different than most. Many people describe the traditional experience of working with an estate planning attorney as hourly fees, kind of a knee-jerk response to problems, and really feeling that they're just treated as if they're just a transaction. The experience that I deliver for my clients really flips that on its head. I do everything on a flat fee agreed to in advance because I want you to have the peace of mind of knowing you can call me as much as you need to. And I'm relationship based. We do everything ahead to avoid problems. My promise to you is that your estate plan leaves no stone unturned and will give you the peace of mind that your loved ones and assets are kept out of court and conflict. The process I go through with my clients is a family wealth planning session, a signing ceremony, and a final meeting. And that whole process takes about 8 to 10 weeks with under 4 hours of actual meetings. And with everything going on right now with COVID-19, I've been doing everything virtually. So you can simply have a tablet or a laptop or a smartphone with a video, and we can do all the estate planning that way. Now, my fees range from between $2,000 and $8,000, and the average is between $3,000 and $5,000. You pick your fee based on what you have, what you need, and your budget. Okay, I know you care a lot about protecting your loved ones because you've spent the last 30 minutes with me really educating yourself in this area. So I know the biggest risk to your family is procrastination. And this is the type of planning that people tend to procrastinate until it's too late. So I really want to make it easy for you. And that's why I'm gifting to you today a $1,000 golden ticket. And what that golden ticket does is give you a family wealth planning session. That's a $750 value for free. And if you decide to work with me, and there's no pressure or obligation to do that, but if you do, you'll also receive $250 off any estate planning package. So that first gift, that complimentary family wealth planning session, that's 2 hours of my time where if you have an existing estate plan, I'll do an audit of that plan. If you don't have a plan in place, then I'm going to go through with you under California law what would happen to your assets if you were incapacitated or passed away. We're going to talk about your family values and the dynamics, and I'm going to give you a full strategy. Now, because this is 2 hours of my time and I'm waiving any fee for it, I'm not going to charge you for it, but there's one catch, and the catch is really valuable to you. I'm going to ask that you turn in homework in advance through my secure portal. And this homework's extremely valuable because it gives me an idea of what types of assets you have, what types of values you have, so I can give you real strategic advice instead of just talking about hypotheticals. Most of all, my clients tell me that turning in the homework has been extremely valuable because it gets them fully financially organized, and that helps avoid future risk to your family. After the family wealth planning session, there's no pressure to work with me, but if you want to work with me, I'll take another $250 off your plan. Now, if you'd like the golden ticket, you can claim it by going to the redemption link, which oops, hold on a sec. Let me put this just here in the chat. You can have it. Yeah, there we go. Okay, yeah. So you can claim a golden ticket by going to the redemption link. You can, I put the link in the chat box and you can enter your information and that will reserve you a golden ticket. Alternatively, if you want to get on my calendar now, you can schedule through the booking link that I put on there. And when you go to that link, it's going to pull up part of my website where you can click on a link and book. I don't take very many of these a month, but there you'll see all the open times. Also, if you aren't ready to book a family wealth planning session, I'd still love to be a resource for you. I'm here to help. So you could schedule a 15-minute complimentary call with me at that link as well. Also, you can email me at the email listed here and in the chat box, or call my office at the number listed. Also, if you head over to my website, you can find some free legal tools, for instance, a way to name legal guardians for free. So that's the end of my planned comments. I'd be happy to answer questions.